Welcome to the Real Estate Syndication Show. Whether you are a seasoned investor or building a new real estate business, this is the show for you. Whitney Sewell talks to top experts in the business. Our goal is to help you master real estate syndication. And now your host, Whitney Sewell.
This is your daily real estate syndication show. I'm your host, Whitney Sewell. Today our guest is Brian Bradley. Thanks for being on the show again, Brian.
Thanks, Whitney, for having me back on again. And, I'm excited about this and for your listeners. And we're going to be blowing up some more of the status quo and misconceptions and then talking about, a great new entry-level protection system for your listeners.
Nice. And in case you haven't heard of Brad, I encourage you to go back and listen to the show WS 431. It came out December 26th of last year. So, but Brian, Brian's a returning guest, as I said, but nationally recognized asset protection attorney for investors. He teaches and presents on higher end asset protection at various global investment summits. He was selected to the Best Attorneys of America list in 2020, Lawyer of Distinction list 3 years in a row, a Super Lawyers Rising Star, and top 100 high-stake litigators list. Welcome back, Brian. Thanks again. Let's just jump right in. Why don't you, though, give us a slight recap of, what we covered in 431. I know we talked about a bridge trust, and I know a lot of the listeners are probably either foggy about what that was or since it's been a while, maybe you could refresh them on what that is, and then let's jump into a few other things that we're going to discuss today in this new type of asset protection that you have.
Yeah, sounds good. And so I guess the recap would just be a good way to start with just, how broken our legal system really is. And, we're simply just a sue happy nirvana. We have more than 40 million lawsuits that are filed every year in the US, and litigation has just become its own $300+ billion business or its own standalone industry. And so what we're trying to do here is just give clients peace of mind. That's what a client's calling in for and asking for when they call in and ask for asset protection. They're saying, hey, I want to be able to have a stress-free life. I want to be able to have some peace of mind, but we can't really do anything to stop you from being sued. We can only deal with how collectible you are. And we do this by placing legal barriers between your assets through the proper use of LLCs, LPs, which are limited partnerships, and a bridge trust. And it's very flexible. You only have one added tax filing and you keep control of your assets. Like I said, the reality is, though, that we can't stop you from being sued. It's just a matter of how collectible you are. And the idea is to make yourself as unattractive as possible to a creditor. And then as you grow with your assets, so does the system. And so to jump into kind of like the full recap, because we went through LLCs, LPs, and the bridge trust before, to recap these layers, the key concepts and the tools we use are these limited liability companies, limited partnerships, and asset protection trust. And so I want you and your listeners to think about winter. Like when it comes to asset protection, you have different layers. I'm from the mountains. I'm from Lake Tahoe. We get a lot of snow. I also lived in Michigan. It gets freezing cold out there. We learn to dress in layers. And the first layer is your base layer and is generally made from merino wool. That's going to sit on your skin. And then you want to have a mid layer on top of that, which is usually going to be thicker and it's going to be like synthetic or it's going to be made out of wool. And then you want an outer shell waterproof layer. And that's going to keep you nice and dry and warm when the weather gets really cold and it's bad out there. But by layering like this, you're now more flexible. When you get really hot and you're skiing or you're ice fishing, you can take the outer layer off or the inner layer off or the mid layer off. You can adjust to make yourself more comfortable. And the same thing goes with your asset protection planning. The base layer is your LLC. That's going to be holding all your real estate. Your mid layer is your holding or operating company. And that's going to be owning and holding your LLCs. You can also put your passive syndication shares into that mid layer. If you're the general partner on those syndications, you would put them into your own separate LLC entity. And then your outer layer shell is going to be an asset protection trust or the bridge trust. And so just to kind of blow up some misconceptions on LLCs.
Could you just quickly highlight those layers again, like the base layer, what it's for, the mid layer, what it's for, and the outer layer and what it's for?
Yeah, the base layer is going to be an LLC and insurance. And it's simply to get the assets out of your own personal name and to limit some liability, some personal liability. Eventually, you're going to outgrow this, especially as you start adding more and more assets, more and more LLCs, your net worth starts growing up. You're going to then want to have a mid-layer limited partnership or a management company to own those LLCs. And the reason is you then want to have a second layer of protection, but you also want to make your tax filings a lot easier. So your LLCs then will be owned by a management company. All those K1s will passively flow into that limited partnership or management company. And so you only have one tax filing. And so it cleans up your system, adds a second tier layer of protection. You're managing that limited partnership or that management company, but you're not owning it. What's going to own it down the line, or if you're ready right now, would be an asset protection trust. The asset protection trust is your really bad weather, you're getting sued, it's a blizzard outside protection. And you generally want that protection, that layer, to have an offshore component simply because of the way our legal system works. You can't run from judgments. You have no real true protection, even if you go state from state. For example, if you're a California resident with a Wyoming LLC or Delaware LLC, you still have to recognize judgments from other states. It's just the full faith and credit clause of our Constitution. You can't get away from it by the way our legal system is. So if you don't have an offshore component in your back pocket, you have no statutory non-recognition. You have no strength or ability to say, I don't recognize that judgment. We don't care. Let's make a deal. So as you grow, even as you're start out with an LLC, just know its limitations, which I'll jump into real quick next. But then as you grow, realize the system's going to grow with you. Then you're going to add another LLC. Then you add a management company when you get to around about 500,000 net worth. And when you hit about $1 million net worth or more, you're either going to jump into a quantum living trust or a bridge trust. When you get past that $1 million mark, you're going to be falling on the line of a bridge trust. If you're under the $1 million mark, you're going to most likely fit into the quantum living trust route.
Is that mid layer going to typically be a corporation, or will it be another LLC?
It wouldn't be. It would be a limited partner.
Okay.
Yeah, and the reason, especially for real estate investors, that you don't want to have a corporation like an S corp or a C corp is because you have ownership shares. Those ownership shares can have a judgment collected onto it. So the LLC came about as a reason to fix that issue with shares. And that's why you see most successful real estate investors using LLCs. You generally would start out, and this is one of the misconceptions, people start these corporations as an S corp because they go to their CPA for tax reasons. And the CPA is going to say, hey, yeah, it's better for taxes to, create an S corp. Well, that's great for taxes, but it's bad for lawsuits and asset protection. So that's generally the pattern that we see. And then when people call in and talk to us, we either keep that base layer and put it into the mid-layer limited partnership, which is fine. Or if you contact your attorney or you contact an asset protection attorney, we'll tell you, start with an LLC. We can always declare to have you file your taxes and be classified as an S corp for taxes, but you don't want shares, ownership shares. So just realize for real estate, you want to have LLCs holding your risky assets. The problem with LLCs generally is that most clients come to me with 15 LLCs and they're all single member LLCs, but they're all in that client's personal name. The problem is that courts have a tendency to fully disregard single member LLCs. So they're basically worthless. What you want is that single member LLC that's holding your real estate to then be held and owned by a multi-member limited partnership. Like I just said, not by you though. But by doing this, what you're now doing is properly laying your protection. And then people really get a lot of confusion on where to set LLCs up in. Do you go to Delaware, Wyoming, Texas, Nevada, and you hear about these states and you hear that they have really good, charging order protection. And so you're like, oh, hey, I'm going to go do that. My CPA recommended that, or I heard about it on the internet. And so I'm going to break down the LLC with more here, since this part of the LLC is not discussed very much. I think people just hear this stuff and they do it and they don't understand what they're actually doing. What really matters in these situations is what is it that you're actually holding when you're creating an LLC. So let's say, for example, it's California, and I'm going to pick on California a lot just because they have no asset protection laws, and they don't really care much about investors. So let's say you own a piece of California real estate that you're holding and you set it up in a Wyoming LLC because somebody on the internet or your CPA told you it was better. And then you go and hold a key piece of California real estate and you put it into that Wyoming LLC and you're paying California franchise tax. What you've done is just convert the Wyoming LLC to a California LLC because you're doing business in the state of California, you're paying taxes and franchise taxes in the state of California. If you're ever going to be sued in that state from that asset, you're going to be sued in California because that's where the asset's at, that's where the injury's at, that's where the jurisdiction lies. You're not going to be taking Wyoming law with you to California in a California lawsuit. Legal system doesn't work like that. So a judge in California or any other state that asset is in doesn't care that your LLC's in Wyoming or Delaware or wherever, if that asset's not in that same state. What they care about is, are you doing business in that state? Did the injury occur in that state? Is the asset in that state? And then that's the state that's going to be controlling in that jurisdiction with those laws. So for assets that are real estate, we recommend using the state that the real estate is located in because you're not gaining anything by using another state LLC. You're just doubling your maintenance cost. And now you also then have to maintain the LLC in two states, the state that the asset's in and the state that the LLC is actually created in. So we just say, keep it simple. And then series LLCs, we have another big misconception when it comes to series LLCs. And the issue is that, they're very young and there's no case law to rely on them. And the only few states that actually have series LLC statutes are limited. What this means is that if you live in a state that doesn't recognize series LLCs like California, you won't get the benefit that's intended from creating it. So you just created a false sense of security. And the really big misconception that I see with LLCs is about, the allure of anonymity and the thought that you can just create an anonymous LLC and that you just disappear and can never be found. And the basic thought is that you can just create an anonymous LLC where you're the LLC member's name, where your name's not going to become available to the public. And you can just completely avoid lawsuits. And this just is false. When your LLC is sued, you're going to be legally required to appear and defend it. If you don't, you're going to have a default judgment entered against you. Then the complaint is simply going to be amended once you do show up, to a deposition. They're going to simply place your name onto that lawsuit. In the US, we have an ability to amend complaints. Also, the simple reality is that, like I said, once the lawsuit is filed, discovery process begins and you're going to be subpoenaed and forced to show up into court. Somebody's going to have to show up and that's going to be you.
So just because they look up ABC LLC and they see some other attorney or some other person's name, they're not going to stop right there if they really want to sue you.
Exactly. They're going to have to show the managing member, the person who's in control of that LLC, which is going to be the owner of it, is going to have to show up and defend themselves and defend the LLC. Someone's going to have to speak on behalf of the company, and it's going to be the managing member. And what's even worse is that if you want secrecy to even work, anonymity to even work, this is also known as lying under oath. And that's a one-way ticket to jail. So an example of this is that very shortly after a judgment is entered against you, the debtor, the creditors, the person suing you, have the legal right to demand information about the assets that you own. And the courts enforce this right very broadly and very seriously. So at this point in litigation, the only way to keep an asset anonymous or a secret is to lie about them and commit perjury. And so we don't advocate for hiding. We just prefer to have full disclosure and a proper asset protection plan and just set it up properly to work. And so part of that is just using the right combination of LLCs in the right jurisdictions with a second tier limited partnership and a really strong asset protection trust like the hybrid bridge trust. And the bridge trust, the strength is that even though it's classified as a domestic trust, it is actually a foreign asset protection trust in the Cook Islands and fully registered offshore from day one. So you get that benefit of statutory non-recognition. And so It's cheaper to start. It's flexible. You don't have any of those annoying IRS compliance and disclosures that you would have to make from fully offshore asset protection trust. There's really no IRS tax filings at all since it's classified as a domestic grantor's trust. But you get the power of that offshore component that you really want and need in your back pocket if and when you ever need it. But unless you have assets and a net worth that are $1 million or more, even the bridge trust can cost a lot. With a full setup with an LLC, an AMLP, and a bridge trust, you're talking about $29,000, which is cheaper than fully offshore. But for a lot of people just starting out, that's still an expensive pill to swallow. So let's say you're growing and you're investing, but you have less than 1 million in assets. Aren't you also going to be concerned about, the crazy legal system and all the stuff we talked about on the other show, out of control politics, lawsuits, taxes? Yeah, absolutely. But the offshore component at that time is just out of your financial reach, but you're the person who needs it the most because you're either starting out and you're going to make the most errors, or you don't have enough net worth to take a big, floating rib shot to knock you out. You won't be able to recover from that. So that's where the quantum living trust comes into play.
Being able to raise money is the number one skill in business, real estate, and syndications. Everything hinges on you attracting capital. If you control the money, then you control the deals. Can you say you're where you want to be with this critical skill? If not, I have a one-time offer to share with you. Right now, get almost 20 hours of recorded content from top syndicators, including Annie Dickerson, Mauricio Raoul, Neil Bawa, Raj Gupta, Julie Lamb, Adam Adams, Vinny Chopra, Annie Simpson, and others who share the blueprint they use to raise up to 8 figures in one single day. Now is the time. These recordings will only be available for a short time, so if you're ready, text videos to the number 55444. That's videos to the number 55444. How's that different from the bridge trust? And let's dive into that. What is that exactly?
Yeah, so the quantum living trust, so let's say you're not at 1 million net worth yet, but you want to have that offshore component for stronger asset protection than just having a standard LLC or anything that's just going to be purely domestic. We just believe that this segment of investors shouldn't be left out of the dark. That's the quantum living trust, and is opening up the doors to who can afford strong asset protection with an offshore component. And it's just easy for these high net worth clients, and most of my clients are high net worth families, to have access to these sophisticated tools like the bridge trust. But this level of protection with the offshore component shouldn't just be left for them. Really my concern has always been about that mid-tier investor starting out 500,000 to 1 million. And the quantum living trust gets you into an offshore component at an affordable entry spot. So for to put your mind around the cost of it, for the cost of a traditional living trust, plus a limited partnership, you can actually have access to an offshore component at half the cost of a bridge trust. So it would be like $14,200. The quantum living trust was designed specifically for this under 1 million net worth asset. And it's just like its big brother, the bridge trust. It's a discretionary, irrevocable trust with a very strong creditor protection with spendthrift provisions, and their self-settled spendthrift trust. The difference is, unlike, the bridge trust that's fully registered offshore, the quantum living trust is not individually registered offshore. That's its limitations. That's what sets it back from the bridge trust. What this means is that the quantum living trust can't by itself be triggered to cross the bridge since it's not registered offshore at all. It has to rely on its primary trust, for its defense. And so it's because of this limitation that once a client hits that 1 million net worth mark, it really is in their best interest to upgrade to the bridge trust at that point and have it individually registered offshore. And so for families with less than 1 million in net worth, a lawsuit can be, like I said, even more devastating to you. And the expense of just defending that lawsuit can eat away and wipe out a significant portion, if not all, of what you built up in your wealth and your investment. And so a large part of the mistakes and errors happen in this beginning stage. So now these, profile of clients have a way to get very strong asset protection, add that missing offshore component that you generally only hear with high net worth families. And then with us specifically, what we do is we will replace the quantum living trust down the road when you qualify for the bridge trust, and just forward that cost of the quantum living trust to upgrade to the bridge trust. But this gives you the offshore component that you're needed.
Nice. So what is that cost difference, or can you share that as well, since you shared about the bridge trust?
Yeah. So the bridge trust is, if you were to do the full package, $29,000, and that's a limited partnership plus the bridge trust. It's just half the cost. So you still need the limited partnership, the AMLP, which is $6,000. The quantum living trust is $8,200, combined $14,200. So it's just half the cost of the bridge trust. And then we forward that cost amount forward to upgrade you to the Bentley, bridge trust later on when you qualify for it. Because there's no point of having to pay something you've already paid half of.
Sure. No, that's awesome. And I can hear one question the listener probably has too, Brian. And I've just wondered, okay, you do something like this, you do the quantum living trust or the bridge, either one, and we are sued. What happens then? I think most people probably listening have not been through a lawsuit, but we have something like this set up, and then, we've hired you all to do that. Are you our first call? What happens?
Yeah. So you would make two calls. Like, first you would call either us
your
or
spouse.
Your spouse. So 3 calls. Call your spouse. Like, shit, I don't know if we can say that. Beep. We're being sued. What do we do? So you would call us and tell us about the lawsuit, what's going on with it, and then you're going to hire, whoever's going to defend you. At that point, you're going to be panicking, most likely, because you're not used to it. You're used to flipping houses. So when you flip a house or doing, your real estate stuff, you see a mess. We see a mess, you see money. When you guys see a lawsuit, you see a panic, and losing everything. For us, it may not be as bad as you think. So our first goal is always calm you down. It's not as bad as you think. 9 times out of 10, we don't have to pull the trigger and cross the bridge. But let's just say you're that 1%er. And it is bad. And we do agree that you have to cross the bridge and migrate. The system is pretty quick. So me or my partner, Doug, or whatever company, firm you go and create these type of trust with, will declare a level of duress, which means we're being sued, but we would be the ones, the trust protectors, declaring it, not you. And it's just for a legal reason for that. It's out of your control. And so that would take about, it was just literally drawing up a document that says, we're declaring a state of duress. And then you would just sign acknowledging that we're declaring a state of duress. We would send that acknowledgement off to the offshore trustee. They would get it, within a day or two. The trust is now purely foreign. At that standpoint, we would just be telling the other party, hey, like, FYI, we have, the offshore component. We are going to migrate, and we are going to take the assets and the equity and take them offshore. So either go away or you get nothing. And we're very open about this, just because the system's so strong, and we're not trying to hide anything. We're just trying to let them know we have the nuclear option in our back pocket. Even if you got the $10 million judgment against us, you'll never collect on it. So go away, or here's a penny on the dollar. Most of the time they just go away. And most good firms will realize that beforehand, because we would be talking to them right when you get a demand letter, and they'll just go away because they're a business. They'll realize there's no money in it for them. And so, businesses have to make money. They can't spend a lot of money without money coming in. Money for these firms are billable hours and, commission rates. If they don't go away from there, we pull the trigger. At that point, the assets control go over to, the Cook Islands. And then we would be talking about setting up, an offshore bank account and connecting that to the Cook Islands, trust account, because the money has to go somewhere. And so at that point, we would either put you in like Uzbekistan or some, a European bank with strong jurisdiction or, friendliness or Switzerland, and we would go from there.
Nice. Okay. It's interesting just to think through some of that. And so, if we're say sued in California or whatever, we have all this set up, but then, I personally, I would say, okay, well, we transferred all this a week later or 2 weeks after we're sued or whatever. Can they not say, oh, that was done after the fact. You got to bring all that back?
Yeah, no, it's a great question. No, because the trust itself was set up years in advance, hopefully years in advance before you're ever sued. So it's all one trust. It's not a matter of transfer. You're not transferring it. It's just what it's called. It's called a transfer, but you're not transferring it to another trust. The trust itself is just one trust, a quantum living trust or a bridge trust. All the assets are in that trust. All we're doing is dropping the domestic compliance of it. The trust is already an offshore asset protection trust. It just has built-in domestic compliance, so the IRS classifies it domestically. All we do is drop those domestic compliance, declare a state of duress, and now it's a purely foreign asset protection trust. Then you're going to have to file those IRS foreign trust documents, the extra ones that you don't want to do, and declare all of your assets. But at that point, who cares? It doesn't matter. You have the strongest asset protection trust in the world.
Nice. No, I appreciate that explanation, Brian. I know the listeners are having that same question.
Yeah.
Unfortunately, we're about out of time, but just a few more questions quickly. What's a way you've recently improved your business, Brian, that we could apply to ours?
Mine. So I'm really into technology and taking hats off, and so I hired a new marketing firm to take that hat off of myself. And I was doing a horrible SEO campaign, which didn't do anything for my business, and so now I'm hired a pay-per-click marketing campaign company that sort of seems to understand my specific industry, and my niche in the asset protection world.
Has that been beneficial?
We'll find out, but it's really new. I'm excited for it though, because I was wasting a lot of money on an SEO campaign that didn't do anything. And then talking to a lot of marketing firms that just didn't understand my business. It's like, you can't market a law firm the same way. I'm not a criminal law attorney, so I'm not a personal injury law attorney. And I had so many marketers trying to say, it's all the same. It's all the same. I'm like, well, my clients generally aren't being sued, so it's not the same. This is preventative planning.
Got to know who your customer is, right?
Yeah.
What's the number one thing that's contributed to your success?
I think just my grit. Life is hard. Business is hard. Owning a business is hard. You're going to fail a lot, waste a lot of money on SEO campaigns that you don't need to do. And, if you just take those failures or those losses personal or let it get you down, you're not going to be able to get through. So you just take what you do right and be happy. You take what you do wrong, learn from it, be happy, and keep going through. And, it's just like, what do they say? That the position on the football field that has to have the shortest memory is the cornerback. Because they're getting burned and touchdowns dropped on them all the time, and they just got to forget about it, line up, and stop the wide receiver next play.
Nice. Great advice, by the way. And tell us how you like to give back.
Yeah, I give back a lot of different ways. Like, I do a lot of pro bono work, not a lot, I used to do a lot of pro bono work, but I cherry pick the pro bono cases that I want to do for free. I also do a lot of teaching seminars on personal growth and business growth, and I generally don't even charge for those. I just like going and talking to people and inspiring them. I've also, was in the process of setting up with Dave Ramsey's group, the school sponsorships, but then COVID kind of put a hold on that. So hopefully we can pick that up next year, when everything kind of hopefully settles down again, and, go in and teach kids in middle school and high school about financial freedom and, raising their financial IQ.
Nice. Brian, thank you again for your time. Always grateful to talk about asset protection. It's so important. I know the listeners need to be thinking about this as well. And just going into the Quantum Living Trust, just grateful for that. Tell the listeners how they can get in touch with you and learn more about you.
Yeah, they can jump on my website, www.btblegal.com. They can email me, Brian, Brian, at btblegal.com. I got tons of educational information on my website, videos, brochures, frequently asked questions. So it's a great educational website just to go on and educate yourself, is the whole reason why I made it so interactive. As well as LinkedIn. I really like LinkedIn. So it's a great platform for building professional networks. And I feel as strong and good your network is how much you're going to succeed.
Thank you for listening to the Real Estate Syndication Show, brought to you by LifeBridge Capital. LifeBridge Capital works with investors nationwide to invest in real estate, while also donating 50% of its profits to assist parents who are committing to adoption. LifeBridge Capital, making a difference, one investor and one child at a time. Connect online at www.lifebridgecapital.com for free material and videos to further your success.